Congress just passed a nationwide block on suppressor and short-barreled rifle tax restrictions, and major organizations are now pushing to eliminate the entire federal registry. Hit subscribe and turn on notifications so you don't miss what happens next in this critical fight. The legislative breakthrough. The legislation that just cleared Congress isn't what most Second Amendment advocates were expecting. While everyone was focused on the big beautiful bill's $0 tax change from last year, representatives introduced an entirely separate appropriations rider that prohibits the Treasury Department and ATF from using any federal funds to enforce tax-based restrictions on suppressors, short-barreled rifles, short-barreled shotguns, and any other weapons. This passed the House with 223 votes and cleared the Senate at 52 to 48, which means it had bipartisan support in an era where nothing gun-related gets bipartisan support. Here's the part that makes this different from the $0 tax change. The previous legislation just reduced the tax amount but left the ATF's authority intact. This new law actually strips their funding to enforce the entire tax scheme. That means the ATF cannot legally spend money on Form 4 processing. They cannot pay employees to review applications. They cannot maintain the database that tracks these items as taxable weapons. What makes this a true victory is that it removes the constitutional foundation the government has used for 90 years to justify the registry. Because here's what most people don't understand about how the registry actually operates, and why removing the funding creates a legal crisis for the ATF. The constitutional domino effect. The National Firearms Act has always been justified under Congress's taxing power, not their authority to ban weapons. When the Supreme Court reviewed the NFA in 1939 in United States versus Miller, they didn't rule on whether Congress could ban certain firearms. They only ruled that Congress could tax them. Every single legal defense of the NFA since 1934 has relied on this taxing power justification. But here's the critical legal problem. If Congress defunds the tax enforcement mechanism, the entire constitutional basis collapses. The government cannot argue they're exercising taxing power if Congress has explicitly prohibited them from collecting or enforcing the tax. Federal courts have consistently held that regulations must stay within the bounds of whatever constitutional power justifies them. In the 2012 case, NFIB versus Sebelius, Chief Justice Roberts wrote that the taxing power can only justify a regulation if there's actually a tax being enforced. Right now, the ATF is in a position where they're trying to enforce registration requirements that were constitutionally justified by a tax that Congress has now prohibited them from collecting. The Government Accountability Office released an internal memo 3 weeks ago stating this creates significant legal vulnerability for continued NFA enforcement. But the ATF isn't just sitting back and accepting this constitutional problem. The ATF's Commerce Clause pivot. Within 48 hours of the congressional vote, the ATF's legal team filed an internal strategy memo that was leaked to gun owners of America. The memo outlines their plan to shift the entire legal justification for the NFA registry from the taxing power to the Commerce Clause. They're arguing that even without tax authority, Congress can still require registration of suppressors and SBRs because these items are sold in interstate commerce. The ATF's argument goes like this. Major manufacturers like Silencer Co., Dead Air, and Rugged produce over 400,000 suppressors annually. 94% of those suppressors cross state lines before reaching consumers. Even for items built at home under Form 1s, the ATF argues that the parts and materials are purchased in interstate commerce, which gives them regulatory jurisdiction. They've calculated that $847 million worth of NFA items were transferred in 2024 alone. And they're using that economic data to justify continued federal control. Here's why this matters. If federal courts accept the Commerce Clause argument, the registry could survive even without the tax justification. The ATF would simply rebrand the same registration system as commercial regulation instead of tax enforcement. They'd still require Form 4s, still impose waiting periods, still maintain the database. The DOJ has already filed preliminary briefs in 3 pending federal cases testing this exact theory. What do you think? Can the government really justify the same registry system under a completely different constitutional power? The Coalition Counterattack. Gun Owners of America, Firearms Policy Coalition, and the Second Amendment Foundation launched a coordinated legal strike within a week of the congressional vote. They filed 3 separate federal lawsuits in different circuits, all making the same core argument. Without valid taxing authority, the entire NFA registration scheme is unconstitutional and must be immediately suspended. The coalition's legal strategy is aggressive. They're not asking courts to slowly phase out the registry or give the ATF time to transition. They're demanding immediate nationwide injunctive relief that would halt all NFA registration requirements for suppressors, SBRs, and SBSs within 30 days of a favorable ruling. Their briefs cite 89 pages of evidence showing that the registration requirements were only ever justified as tax enforcement tools. But here's the leverage point that makes this different from previous NFA challenges. 28 state attorneys general have filed amicus briefs supporting the coalition. That's 56% of states telling federal courts that their citizens should not be subject to a registration requirement that has lost its constitutional legitimacy. The real power move, though, isn't happening in federal court. It's happening in state legislatures where lawmakers are preparing to make NFA enforcement functionally impossible. The state sanctuary firewall. Montana just became the first state to criminalize NFA registry enforcement within its borders. The law, which took effect January 15th, makes it a state felony for any person, including federal agents, to enforce NFA registration requirements on firearms manufactured and kept within Montana. The penalty is up to 5 years in state prison and a $50,000 fine. Wyoming, Idaho, and Kansas passed similar laws in the last 2 weeks. Yet Alaska is advancing legislation that goes even further. It would make suppressors and SBRs exempt from all federal regulation if they're manufactured in Alaska and never leave the state. The Alaska bill also authorizes the state to provide legal defense for any citizen prosecuted by the federal government for possessing an unregistered suppressor or SBR. Texas is taking a different approach. Their legislature just introduced a bill that would require the state to challenge any federal prosecution of a Texas resident for NFA violations. The bill allocates $10 million for legal defense and explicitly directs the Texas Attorney General to argue that the NFA registry is unconstitutional following Congress's defunding action. The practical effect is this: if 15 to 20 states pass sanctuary laws, the ATF cannot physically enforce the registry. The entire system depends on voluntary compliance backed by the threat of federal prosecution. But if states make that prosecution impossible or prohibitively expensive, compliance rates will collapse. And that's exactly what's starting to happen in the private sector. The industry stampede. Silencer Co. just announced they're building a $30 million production facility in Utah, designed to produce suppressors at 10 times their current capacity. The facility is scheduled to open in June, and the CEO explicitly stated in the press release that the expansion is based on their projection of a post-registry market. Dead Air Armament, Rugged Suppressors, and CGS Group have all announced similar expansions. The suppressor industry is preparing for demand to increase by 500 to 800% once the registry falls. Here's the economic reality. Suppressors currently cost between $400 and $1,200. But manufacturers estimate that in a post-registry market, prices would drop to $150 to $400 due to increased competition and volume production. The current market is about 400,000 suppressors sold annually. Industry analysts project that could increase to 2 to 3 million annually if the registry is eliminated. That's a $600 million market, expanding to potentially $2 billion. Short-barreled rifles present a different situation. Right now, Most gun owners don't build SBRs because of the registration hassle and the fact that pistol braces created a legal workaround. But if the registry falls, the market for actual short-barreled rifles could explode. Companies like Daniel Defense and BCM are already designing new product lines specifically for a deregulated SBR market. The ATF knows all of this, which is why they're preparing for the absolute worst-case scenario. If the registry actually falls, would you immediately buy a suppressor, or would you wait to see if the ATF finds another way to regulate them? Let me know in the comments what you'd do. The ATF's Doomsday Contingency. A confidential ATF planning document leaked last week reveals the agency's contingency plans if federal courts rule that the registry must be shut down. The document, labeled Post-Registry Transition Framework, outlines how the ATF would attempt to maintain control even without statutory registration authority. Their primary strategy is to pressure federal firearms licensees into voluntarily tracking suppressor and SBR sales through existing Form 4473 records. The ATF would issue guidance stating that while registration is no longer required, FFLS should note in the remarks section of Form 4473 when the firearm being transferred is a suppressor or SBR. This is clever because Form 4473 is already required for all firearm transfers, and FFLs already maintain those records for 20 years. The ATF could then use their existing inspection authority to review those records and effectively reconstruct who owns suppressors and SBRs without formally requiring registration. The leaked document estimates this would capture approximately 70% of suppressor transfers and 60% of SBR sales, even without mandatory registration. The second contingency involves reclassifying suppressors under different regulatory authority. The ATF's legal team is researching whether they could regulate suppressors under the Arms Export Control Act, or classify them as destructive devices under a different section of federal law. But there's one group of people this affects more than anyone else, and they're completely unprepared for what's coming. What current NFA owners need to know. There are currently 6.2 million registered suppressors, 4.7 million registered short-barreled rifles, and 1.9 million registered short-barreled shotguns in the NFA registry. If that registry is eliminated or shut down, every single one of those registrations exists in a legal gray area. Whether the restrictions on interstate transport would disappear, or whether the registration data would be destroyed or maintained. I consider this scenario: you legally registered a suppressor last year, paid the tax before it went to $0, and now you want to move to a different state. Currently, you need ATF approval to transport a registered NFA item across state lines. But if the registry is shut down and the ATF no longer has authority to enforce registration requirements, does that approval requirement disappear? Can you simply move with your suppressor? What if you get stopped by state police during the move? The legal advice from most Second Amendment attorneys right now is don't do anything. Don't file new Form 4s if you can avoid it. Don't voluntarily surrender your tax stamps. Don't transport NFA items across state lines until courts clarify the situation. We're in a period of maximum legal uncertainty, and that uncertainty could last 6 to 12 months while courts work through these cases. For people who built suppressors or SBRs under Form 1, the situation is even more complicated. Those items were literally manufactured as registered NFA weapons. If the registry disappears, do those items remain legal? Do you need to keep proof of registration? What's certain is this: the next 90 days will determine whether 13 million registered NFA items become freely transferable or remain in regulatory limbo. The 90-day timeline. 3 federal judges are currently reviewing the motions for summary judgment in the registry cases. The Fifth Circuit case has a hearing scheduled for February 18th. The Ninth Circuit case has briefing that closes on March 3rd. The D.C. Circuit case is moving slower, but oral arguments are set for March 20th. All 3 cases are asking for the same relief: immediate nationwide injunction, shutting down the NFA registry for suppressors, SBRs, and SBSs. We should see at least one district court ruling by late February. If the plaintiffs win, the government will immediately appeal and request a stay of the injunction while the appeal proceeds. That stay request would be decided within 7 to 10 days. If the appeals court denies the stay, the registry shuts down while the appeal is pending. The absolute best-case scenario is this. One district court grants the injunction in late February. The appeals court refuses to stay it, and the registry goes dark in early March. Suppressors, SBRs, and SBSs would be transferred like regular firearms for 6 to 12 months while the appeals process plays out. During that time, millions of Americans would purchase these items without registration. The worst-case scenario is that all three courts rule for the government, the appeals courts affirm, and the Supreme Court declines to hear the case. In that scenario, the registry survives despite Congress defunding the tax mechanism. The most likely scenario falls somewhere in the middle. At least one court grants partial relief, creating a circuit split that forces the Supreme Court to take the case. That would put the final decision in front of the current 6-3 conservative majority. Here's what I want to know. If you had to bet on which scenario happens, registry shutdown in 90 days, government wins everything, or Supreme Court splits the difference, what would you put your money on? Drop your prediction in the comments because 3 months from now we'll know who was right. If you found this breakdown valuable, smash that like button, drop a comment with your predictions, and subscribe so you don't miss the rulings when they drop. Hit the notification bell because this situation is moving fast. Thank you for your support, and I'll see you in the next update as this develops.